Noted. I understand that they say the link on the flyer is displaying an error message when it is used.
That's what one person is saying. The link on the flyer was for registration. So if anybody has registered, and we had over almost 200 people who had registered. So those people ideally should be able to log in because they are sent, once registered, they are sent a special link.
Can you send the link again, maybe to the chat box, so that we could just circulate it once again?
Okay, I will do that now.
And can people still register?
Yeah, people can still register.
Ikechukwu, how are you?
I'm fine, NSL.
Long time. I hope you have not joined the rebel.
Not yet, sir.
Because it's paid to be a rebel now, rather than
it's also a very dangerous option.
So that I can negotiate with you.
Indeed, trying times.
It's a trying time for us. So this country.
Right. Okay, I'll do that. Okay.
Yeah, that's the link. I've sent it to the chat box. So some of our audience are also going to be watching us from Facebook as well as streaming that. So it's not just a Zoom. So as we go on, people will also ask questions on Facebook, and then we try to get those questions for our panelists to answer while we are here. So that being said, should we start?
I think so, because Prof says he will leave by 4, and for me, I will also leave after Prof must have left.
Okay. So
and it's already
it's already 18 minutes past time. So okay, so we start. So welcome everybody to today's Raising the Bar webinar. The webinar intends to address issues that involve the changing environment for the legal profession in Nigeria today. You're all welcome. Thank you for taking our time to join us. We have a number of speakers, actually. We have quite a lot of very strong legal minds as our speakers. We have, as our keynote speaker, we have teacher, Professor Ernest Ojukwu SAN. We know him as a professor of law, senior advocate of Nigeria, a partner at Ojukwu Yusuf and Fautu. He's a founder and is a former deputy general and head of campus of the Nigerian Law School, Augustine Namani campus, Enugu. He's the founder and pioneer chairman of, in fact, he has a lot of things. We all know him. Very welcome, Prof. The next person I have on my list, which is a panelist, senior, Mr. Jibril Okutekpa SAN, is my Oga. He is a senior advocate of Nigeria. He's the founder and principal at JS Okutekpa SAN & Co. He's the lead prosecutor of the MBA at the Legal Practitioners Disciplinary Committee. And he's a member of the General Council of the Bar as well, and a NEC member of the MBA. Again, he has his profile is quite long, so I'll just keep it as brief as possible. You're very welcome, Mr. Okutekpa, sir.
Thank you. I used to be chief prosecutor, and I also used to be a NEC member. I was told I'm a member of General Council of the Bar, but I have not gotten a letter of appointment. So let me correct those three something.
All right, sir. Thank you very much. Amiraku, please take note.
Yes.
I noticed that Mr. Atoyebi had come online. I don't know if he's still online. I noticed that Mr. Atoyebi had come online. I can't see him online. Okay, so I go on. I think Chief is also online now. Yes. So Chief Bola Akinola is also a panelist. He's a chartered arbitrator. He's a fellow of the Chartered Institute of Arbitrators, FCIA Arabi. He's the vice chairman of the Chartered Institute of Arbitrators UK and one of the founding partners at the Law Union. He's a former president of the Maritime Arbitrators Association of Nigeria and a former special assistant to the Honorable Attorney General of the Federation and Ministry of Justice. So please welcome, you're welcome, Chief Akinola.
Good afternoon, all.
Good afternoon, sir. So we also have a very interesting Mrs. Obose Apata. She's my madam, but she doesn't know yet. She's a chartered arbitrator. She's a fellow of the Chartered Institute of Arbitrators. She's also an accredited mediator of the Center for Effective Dispute Resolution, CEDR. She's an associate at the Chartered Institute of Taxation of Nigeria and the managing partner of Patrelli Partners. She's currently the chairman of the Arbitration and ADR Committee of the MBA section of Business Law. Ms. Akpata, you're welcome.
Thank you very much.
Okay, I'll just, so the next person here is my Oga that knows himself. He's my Oga and he knows himself. Mr. Ikechukwu Wana is the managing partner of SEDAC Attorneys. He's a fellow Chartered Institute of Taxation. He's former secretary of the MBA Lagos branch and a member of the National Executive Committee of the MBA. He's the secretary of the Law Firm Management Committee of the MBA section of Business Law. He's one time this, one time that. He still has a long profile. Welcome, Mr. Owana.
Thank you.
Leonard Silk Adeborua seems not to be online. Leonard Silk Adeborua seems not to be online, but we expect him to come online afterwards. We also expect Mr. Atoyebi SCM to join us, but as soon as he does, we'll give him the recognition he deserves, and then we'll continue. So you're all welcome. Everybody, you're welcome. I'm the moderator of this session, but I'm not moderating alone. Moderating with me is Mr. Jude Stadios rather. No, sorry. Please don't be angry. So Mr. Anodun will be playing a very important role at this session. He's going to be moderating the session. So at this point, even before I say anything, I know I've not introduced him well. I'm sure he's in a better position to introduce himself. So let me hand over to Mr. Nodun. Please do the honors, Nodun.
Good afternoon, Leonard Senior Advocates and panelists. My name is Jude Thaddeus Uchenna Nodum. I'm currently a fourth-year student, PhD in law student at the University of Sussex. So I'm currently zooming from Sussex, and I'll be co-moderating this webinar.
Hello?
We can hear you. Please go on.
Oh, I've just said that I'm currently a fourth-year PhD in law student at the University of Sussex.
I've actually just handed over to you, so you should carry on with the session now.
Oh, okay. Oh, okay. Thank you and welcome, everyone. So we shall be starting with our keynote speaker, who has already been introduced, Professor Ernest Ojukwu. Sir?
Yes, good afternoon. Good afternoon, everybody.
Good afternoon.
My sleepy Jess and the rest of us, good afternoon. Yeah, my brief is to present a keynote on the theme of the webinar. The background to it from the theme of the webinar is that it addresses colleagues who are already in the legal profession and want to advance in the legal profession. Always the challenge is that, and that's one of the reasons why you don't have, in spite of the number of people who have registered, they are not quite here. The reason is that majority of colleagues in the profession don't want to be in the profession. They want to hear about something else other than how to advance in the profession because they have seen no future in the profession. So all the time, we always make a mistake when we address lawyers because everybody's wearing black, as if all of us want to be lawyers in reality. Some may want to be, but they have seen the challenges, and it seems that the roadmap is not very secure, at least the way we have presented it from their training to their practice time. So I will still address the theme as I've been asked to, but I would like to start with a few other remarks relating to the background I have already painted. Based on various estimates, because we don't love data, there are about 100,000 lawyers enrolled in Nigerian Bar since its establishment, and an average of 4,000, 5,000 wigs, new wigs or green wigs are initiated into the profession yearly since the past 4 years. According to UK Vanguard's 2014 survey, whilst about 43% of Nigerian lawyers who have started practicing upon enrollment dropped out within the first 5 years, they never get to work in the area where their legal training is most relevant until they choose to. They are close to about 80 who score. We also have a police survey of 2016 that reported that a further fraction of 35% out of the rest of 57% of Nigerian lawyers who remained in practice in their first 5 years eventually changed their career path, though within the law practice. In an interview conducted by one Dr. Oshikoya of the School of Orientals and African Studies, University of London in 2010, many lawyers in Nigeria were unaware of the avalanche of career paths available in the legal market, and wish they had been better informed at the early days of their professional pursuits. That's the background of what my discussion, introductory discussion focused on. So most times, the congestion at the ladder base of the Nigerian legal market appears to paint a message that lawyers are too many in Nigeria, unlike the 60s and 70s. Unemployment and underemployment in the Nigerian legal industry is disturbingly sprouting without any deliberate check. However, in 2019, Pew Research puts the ratio of a lawyer to client in Nigeria at 1 to 9,500. So you see, we are nowhere near having enough lawyers to service the industry and access to justice. But in spite of this, many lawyers that will graduate still opt out of the profession. And this leads me to my presentation, which is based on a theme, raising the bar, the changing environment for the legal profession in Nigeria. I have dubbed mine technology innovations in legal practice, to think about other ways how we can help mainly the younger ones who are bent on fighting and surviving in the system for the purpose of making their career here. I tell people generally that you don't need an office, for example, to practice law. You don't need an office. The only thing office does for you is to provide you environment for studying, for housing your books and materials, and for meetings. As many clients now, especially at the levels of GS Okutebe's level, don't come to the offices. They send you emails, send you letters, send you their briefs in writing. Probably maybe when you go down to the local environments where you have the community where they're less capable, where mostly you have to do pro bono anyway. Those are the places you see many clients come physically to the office. Otherwise, at Abuja, Lagos levels, lawyers don't need the clients. So I would like the host to, if you can, give me, enable my share screening so that I can share the PowerPoint with everybody, so it will be faster and to go through it. You can enable my screen, my share screen. As you may see, my background dovetails with my own topic, technology innovations. That's why I chose my background. I'm, already flying in the moon, so I want everybody to join me in taking off to the planet. That's why I have that behind me. As a matter of fact, I was called to the bar in 1985, but by 1992, I was the first lawyer to go technology in Aba. By 1995, I was the first lawyer to use the Windows 95. When I started using computer in 1992, it was DOS. I don't know whether any young guy understand what DOS means. We go to the computer through the door. Then Windows was created for lazy ones who couldn't understand the formula for entering the door. So they created the window like thieves. They can always enter through the windows. So that was why the Windows came, and the Windows was given some challenge until they were able to get the Windows 95. So I was first also to use the Windows 95 as a young lawyer. I was also the first lawyer in Aba, and I could say in the Abia State to also use, go to internet and use internet then. Then it was links up. When you die, it will do, you wait until it connects, and then you log in. So it's a long time we left the planet. We're looking for people to join us somewhere else. So am I enabled now, or do I go ahead? It looks like the host is also not technologically very good to connect me, allow me to share my screen. It's still looking for the button, so I'll just go on. Now, I've also sent the material to the host so he can email it to everybody. So the first thing I said was to do you a list, just a list of innovations in technology that is connected to legal practice, because I want young lawyers to drive their legal practice through this window of technology, because that's the only way. You can't afford, if you're in Abuja, the millions of naira you need to hire an office. And even if you do, like as a team, as a group of lawyers, and hire one, the space may not be too conducive for all the time for everybody to be in that same office at the same time. So you may need to share space. And therefore, if you need to share space, it may be best to also have the days you will not be in the office, use technology to conduct your work. We will have the challenge of having the other people, like the court system, key into your technology, but don't wait for them. Keep advancing. One, they'll catch up, but the more you get advanced, because your own type of practice may not necessarily be pure litigation. You may be into transaction law, and you can be explaining to and most serious transaction clients will be ready to pay for the services, and you can't explain to them that you can do some of the things that technology has provided us opportunity to use. Of course, there's a court electronic filing, not that Lagos caricature, not those Lagos caricature. When you say you have Lagos filing and people spend 3 months photocopying and scanning documents, that's not, but that's actually a debasing of the system. There's court electronic filing, there's electronic law office, there's websites, blogs, and use of online media. Many young people are used to the blogging system, but only for show, for socials. They're not very used to it for work. There's age of technology and legal practice. There are consortiums. People form consortiums. You don't need to. I will get back to the law. Good, JS is here. Probably have to look at the rules of professional conduct to see what we can do with it, because Many cases now, some clients will not allow you to approach them standing as a law firm alone. They need you to have a consortium of people, of experts. AMCON, a couple of them do that. They won't give you that brief for recovery unless you are coming as a consortium of lawyers, surveyors, valuers, bankers, accountants. If you don't have that kind of consortium, meanwhile, the rules of professional conduct challenges some relationship that between lawyers and non-lawyers, but we have to explore how can. But surely, if you don't form a consortium in that regard, you are not going to get a job. And international big transaction businesses will require you to come as a consortium. What does? Surely you're not going to get it if you don't come. Even as a consortium of only lawyers, they don't want to see one law firm handling that kind of big transaction. So young lawyers may have also think about keying into creation of consortiums to do ad hoc jobs or a more longer span job, not permanent though, but longer than just ad hoc. Okay, of course, there's litigation funding, which we don't know anything about in our system. But in other countries, including the common law country, UK, where we took our own profession from, there is massive legalized litigation funding, where companies form are incorporated only to fund litigation. So if you want to sue for Ogoni people, they are not likely to have money to fund a big, cleanup system, oil cleanup, pollution cleanup thing. They cannot afford it. You're going to take millions of naira. You may need to sue in England or somewhere in Europe or even Nigeria, but you need to join so many people from it. You need a lot of money. And so there's litigation funding. You approach companies. Look, we want to sue for Ogoni people, but we need them to, we need a funding for it. So the funder will pay the services of the lawyer, pay for other services, valuers, everybody. And then on recovery, on contingents, the litigation funder is paid, and it's legalized everywhere. It's in law, it's in rules. We don't have it in our system, but we need to drive that kind of innovation so that we can now have employment for the lawyers. The lawyer scope of work covers representation, advocacy, negotiation, and evaluation. But so many people seem to be tied to only one small aspect. Go to magistrate court or customary court and carry 100 files and run helter-skelter until they faint. Of course, there's ADR and arbitration. There's prepaid and group legal services where certain companies form a prepaid system. And we have seen some challenges from companies like the telephone companies and banks trying to create such group prepaid legal services, and we're challenging them. Of course, there's a limit for that challenge. It's not that later we'll not be able to challenge them. But so lawyers need to begin to think about creating those services themselves. It's not allowing First Bank or MTN to do it, or Union Bank. Lawyers need to do it themselves, because there's a limit. When a dam bursts and you shovel sand and all pack sands and try to contain it, there's a limit. After some time, it will burst again. So instead of waiting today to burst again, why not form your own dam and start collecting the business? Don't worry about the rules of professional conduct. If you are interested, lawyers, the young ones, will challenge the system and make the system change the rules. There are law-related services, of course. Well, one of the major problems about law-related law practice in Nigeria is that in other countries, the law or rules provide what are exclusive businesses for lawyers. And there are about 3 or so categories. The other one that are not exclusive, the other one not lawyers' business, what lawyers can do. Here, nothing says anything about what lawyers' business. We don't know our business. We assume we know, including litigation. We assume it's our business. Who's told you that? There's no law, there's no rule saying this is your business. In other places, categories into 3. Exclusive to lawyers. Lawyers can share with others, but it's a lawyer's business. Non-lawyers' business, but lawyers can do. We don't have it. Otherwise, we explore those lawyer-related businesses without trouble. Of course, there's judgment, executions, receivership, expert witness, notaries public. We don't have to be all in execution. You can just carve out a niche and just be a person focused in execution. Go and train, including security services. You need to have a kind of training and background to be able to deal with judgment executions. And so because lawyers are incapable of executing their judgments. And so many lawyers assume because they got a judgment, they're able to execute it. No, it's another business. So in other places, law firms that hire other law firms and other companies to execute their judgments. They don't go back because it's a way you can't mix it up. So lawyers can set up companies or law firms focus on the execution of judgments. It's like receivership, like expert witness. You don't need to create an expertise in one or two areas and focus on it. And then you can be called up in many jurisdictions, including outside the country, to testify. That would be a business, and it gives more money even than litigating as a lawyer. Of course, notaries public, which is abused, 100% abused. We don't have a good notaries public law. We're thinking about it too. So many lawyers with notaries public certificates delegate it to clerks, and people just keep stamping them, but we don't have ethics for it. But that's a business. Of course, as I mentioned, you do a specialized cadre. So in that group of lawyers that you have assembled together among yourselves, you could do specialization so that it becomes easy to have a one-stop shop in your environment. And many clients would like to come to. It's like going to a supermarket. The smaller smaller number of goods you see on the shelf will not be an incentive to enter the shop. But when you enter a shop with different goods, so many, pots, pans, foodstuff, fruits, different. You see more people want to go to that shop that has different varieties and plenty of things. But when you only have orange in your shop, people trickle in, and that's what a group of lawyers having specializations in one-stop shop does. It attracts clients to come there. So rolling out all these things, I'll just run through a few things that are already in place in the world that helps to drive this technology focus for legal practice. Of course, the Anzium. Anzium is an online law firm, provides lawyers placement for companies, deals with traditional law issues, uses registered lawyers to achieve its purpose. We have the Up Counsel platforms that has profile of several selected lawyers. Clients or companies post their legal needs and is shown on a list of Up Counsel lawyers. Client selects one of them for her legal needs. You have the Meritas, for example, worldwide online platform. Lawyers register as members. Platform refers lawyers to clients. Publishes materials to train members. You have the Prior Legal. It's an online platform used to hire and manage top lawyers for businesses at extremely competitive rates. Clients post a project or work and he's attached to a particular lawyer. The client will rate the lawyer on the platform. You have the Civil Resolution Tribunal of British Columbia, province of Canada, created by the Canadian province of the British Columbia. It's an online tribunal that resolves small claims disputes of up to $10,000 and under. And the strata property, like we call the condominium of any amount. It uses a range of dispute resolution tools, including negotiation, facilitation, and arbitration. And parties can resolve the disputes online from wherever they are without coming to court. You have the legal analytics, different types of legal analytics. I think even the law development is trying to create a form of legal analytics. This one is designed by 2 law professors and a data scientist and consultant that applies machine learning and artificial intelligence techniques to identify patterns in the case. It makes predictions as to the outcomes of cases before the US Supreme Court. Currently has an accuracy rate of 70%. 70%. So you can predict the outcome of the case. I don't know how it will apply in Nigeria, where suddenly they will take one case and give it to a new governor in Imo State without any legal analysis. Okudepa has many such cases. I'm sure he will talk about. He may talk about if time permits him. So I don't know how that kind of analytics can work. You have legal shield, create personalized, specified agreements, personalized agreements drafts. The user provides information for the agreement and the application of drafts. The agreements are designed online. The agreements are binding. Many types of agreements. Clients with questions can contact already available lawyers or law firms. Now we have, let me just, many. So let me not bore you with so many, but you post this PowerPoint to everybody. So those are just examples of many innovations that are already in the market and affecting legal practice and used by lawyers. Now, some of them are created by lawyers, many are not created by lawyers, but what lawyers are doing in other jurisdictions is to tap in and conquer those services, conquer the system. So otherwise, you stay outside. The more you stay outside, the more you lose the ground. And sooner than later, we all lose our jobs, because when they deploy these machines to begin to be the judges and arbitrators and mediators and do the documentations and do the analytics and predict the decisions, we're out of job. So we need to begin to learn how to manipulate these systems for our own benefits and services of our clients. Now, many challenges in Nigeria, apart from our education, which if I talk about it, we'll probably spend 1 week discussing the failed legal education in Nigeria, from our LLB to the law school up to now. Our legal education is a failed legal education. It has done some reforms in a few years back.
I'm really not getting Prof anymore. I don't know whether.
Let me see whether I lost. Am I lost? Am I lost?
I'm no longer hearing Prof.
I can hear Prof. Prof, I can hear you.
Can hear you, Prof.
You have to, if your system must be, can you log out and log back? Let me just see, be sure it's not my system, but I must be heard by some other guys. So
Yes, Prof, I can hear you clearly.
Yes, Prof, I can hear you.
Yes, you may have to log in and log out and log back immediately. So that means your internet is creating problem where you are. Okay, good. So I go back to the challenges. While we may have some young lawyers who may want to key into these innovations, there are still challenges in our environment that may prevent an easy transition to these innovative level of legal. And one of them I said is our training. We can't address it here. We're not going to change legal education in this webinar. Neither we're going to change it without conquering the system, and we're not going to do so soon. So the system will still be wobbling in our training. So we need to agree that once you're out of the system, you need to begin to learn again on how to capture the system, how to retrain yourself to join the innovative train. So if you depend on that legal education, you surely be out. That's one challenge. Second challenge is the rules. Rules and culture. A lot of myopic and traditional culture, and many of them based on misinformation and on ignorant training, has led us to not to think using the rules we have, even with their challenges. One of them, for you to do most of these things that I have highlighted, that innovation, technology has given us opportunity for, you must have capacity to advertise your business. If you can't advertise your business, you are not likely to conform or use these innovations effectively. You could see some of them I highlighted needs you to advertise. Otherwise, how would the client, if you don't go and putting your name in that group for them to connect you to a client, you have to advertise it. Somebody has to connect you. That may be, say, champagny. So we need to think about our rules too. But before we begin to change our rules, we need to use the little openings that we already have, for which many people keep saying they don't have capacity to. Now, there are two things. Our rules of professional conduct, 2007, which I've produced the final copy, that is the rule, permits lawyers to advertise, permits lawyers to advertise even on television and on billboards and in newspapers. People say, we can't advertise. I say, what the hell is that? Where did you see that? It clearly tells you that you can advertise. Now, an aspect of it which people read wrongly, which confuses them, is that there's an aspect of it that says you cannot solicit in any form, even by advertisement. So there are two levels. Says you can advertise, and it provides you with 5 things, 5 tests for that advertisement. If you do not conform to those 5 tests, then your advertisement will be unethical, will be against the rule. That's clear. It says these 5 tests, your advertisement must conform to these 5 tests. If they don't conform to these 5 tests, then you are out of the rules. Then it goes further to create a rule against solicitation, total ban, and gives you circumstances you cannot solicit even through this, including an advertisement. And people turn around and say, okay, that means we can't advertise. No.
I don't know. I'm not hearing Prof. I don't know whether everyone is hearing him.
Were you able to log out and log in again? Okay, can someone type for him? Can you type that you should log out and log in? Can people type for him to log out and log in since he can't hear me? Or can someone else unmute the mic and tell him and see whether he can hear the person?
Sir, I've done that. I sent a message to him on WhatsApp. I've done that, sir.
Okay, not only WhatsApp, you can type it on the chat too.
Okay, I'll do that, sir. And
you can even call him on the phone if he's not using the phone.
I'll do that.
He must have some Obanje on his phone. All right. So we need to distinguish that. So based on that, it's only bouncing for and the clear distinction. There's a clear distinction between advertisement and solicitation. Clearly, in the Blackstone dictionary, in the rules of professional conduct of many jurisdictions where we copied it, including the US. In the dictionary itself, there are clear distinctions. So what it bars is solicitation, not advertisement. And advertisement is going on in Nigeria. And the unfortunate thing is that the only people advertising are the senior lawyers. The junior ones are not advertising, and are feeling afraid to advertise. Yeah, because of ignorance. And this is where it is the young lawyer that requires more advertisement than the senior lawyer, because those old ones have already been known and they can survive on 2 clients and 3 clients, big clients. But the young ones need to break into the market and so advertisement. So you start with the little ones. Okay, I'll show you a few differences between advertisement and solicitation at the end, but so that you just talk about this generally. I'll show you the little ones. Well, for example, there's the Facebook. Young lawyers are all over the Facebook, but the only thing they do is post of pictures and so on. And there's an aspect of Facebook which you pay. You pay 1,000, 2,000, 3,000 and advertise a statement, advertise it. So even if you have a reach of 5,000 people connected to you, when you pay for on your page, if you pay for a statement on your page and send it out, depending on how much you want, it can reach 40,000 people, 50,000 people. If so much, and you have to pay for it, 1,000 something, 3,000 something, once in a while. But young lawyers are not doing that. They're only doing Facebook of photographs and all those things, party. There's LinkedIn, which is the professional one, fully professional. It requires you to advertise things there. It requires you to talk about yourself. Young lawyers are less in LinkedIn in Nigeria. They're not there. And it is LinkedIn that is for the professional. You write small articles, more comments on some different areas of the law, so that somebody can pick it up. Because people are looking for lawyers that can do real job. Forget about the fact that lawyers are all over the offices. People are not looking for lawyers just by looking at the signboard. They're looking for the experts, just as we look for experts or doctors. Even when we see 10 clinics on our street, we still don't walk in there. We still want someone to tell us about a particular doctor to go to, even if you have to travel to another city. So that's the same way they're looking for lawyers. And LinkedIn is where people look for it. There's also the Twitter, which you can use to advertise what you have advertised on LinkedIn or on Facebook, and so on and so forth. That is a small aspect. If you do not have the money, even though it is still a little money, to create a website. You don't need to pay anybody to create a website. My first law firm website was designed by me, paid for me by me. It's less than 25,000 naira a year. You can design a static website and bring it down every year and change things for it if you want that one, at least a static website. Do it yourself. You don't need any expert, no person at all to create a website for you. If you need, there's so many young guys who are ready to give you that service at very small money. So you can design a dynamic website that doesn't have too much in it and use it as a starter and advertise yourself and push the website on Facebook, push it on LinkedIn, push it on Twitter. Now, the few things I said, let me just explain that advertisement again. Now, let's look at this advertisement. I'm sorry, you can't see it. Oh dear. Yeah, I wanted to show you. So I think I'll need to wrap up here since I can't show you these videos and photographs. So it's unfortunate. Maybe we'll have another opportunity to do that. I think I should end here just to agitate your mind. That's what Keynote is supposed to do. Just raise your temperature, keep some cool water around so that you can also pour it when your temperature is rising. Thank you.
Thank you very much, Professor. You have actually really shown us why you are called a teacher. You have taken us, in your own words, to the moon with you. Thank you very much. Professor, in his speech, has been able to highlight and elaborate why and how we can position ourselves as lawyers, both young and old, in the ever-changing environment of our legal profession. Thank you once again, Professor. Building on this, I shall be calling upon the next speaker on our panel, Mr. Okutepa SAN, sir. Please, the floor is yours, sir. Thank you.
Thank you. I didn't know whether Prof said that my phone was suffering from Ogbanje. I think what happened to me actually gives me the opportunity to speak my mind on looking at the changing environment for legal profession in Nigeria. All the beautiful arguments that Prof raised, I was denied the opportunity of capturing majority of them for no fault of mine, but for the fault of the society and the technological advancement that we have in this part of the world. And that was why when I got the invitation to speak on this matter, I decided to change my, give to myself the topic within this webinar, the challenging issues for the legal profession in Nigeria. I've circulated my paper already, and I'm sure you must have seen it. So I will not waste time to read it or go through it, but I want us to start focusing on ourselves. All that Prof has said, including having legal business, the question that there are no defined legal business for Nigeria, we jump into all manner of businesses in this country, are challenges that are inherent in ourselves. For instance, it's no longer news that all of us on this webinar may not likely to come together to form a consortium of law firm for purposes of maximizing legal practice. The reason is very simple. We have no trust for ourselves. And each and every one of us wants to either be Professor Ojukwu without following the paths that Professor Ojukwu followed from Aba. He has told us now how he was the first lawyer to start using internet somewhere in a place that is called Aba. That's supposed to be a commercial hub center of Nigeria. But if you go to that place that produces all the wealth for the eastern part of this country and for the Nigerian part, you will weep for yourself that is a place that produces erudite prof like Professor Ojukwu and a lot of lawyers. And so I was looking at the challenges in our society that will affect the changing environment that we require. And one of it that I look at it, for instance, is our own attitude as lawyers. Now, if we decide today and say, let Professor Ojukwu, myself, Mrs. Akpata come together, there is question of trust. Do we trust ourselves within the rules of our ethics to be honest, integrity-driven, and be in a position to put ourselves again. I'm sure you have lost me or lost my voice. I'm sure you have lost my voice. You have lost, the thing went off, it's coming back again.
You're back now, you're back.
I'm back now.
Yeah,
so when you look at the paper that I sent to you, I look at our society. In all of these things we're talking about, Prof talked about, you don't need to have an office. You can transact legal business from your bedroom. First, do we have the technological advancement to do this legal business? Even if all of our characters is 100% correct, you discover we don't have the power holding company. Since I came to I've NEPA, or is it NEPA they call them now, or Disco, they have taken like not less than 7 times. And each time my generator comes on its own, they bring it back again. So I look at the environment, our society, and I say that we are not prepared to embrace the change. The government is not prepared, and you and I don't have the capacity, apart from this discussion. Perhaps the discussion we're having on this webinar will end up in this webinar today. Nobody will listen to us and make use of it. So I look at that. Then Prof talked about the rules of professional conduct. Even within the rules that we have today, are we effectively and efficiently following the rules? I've had the privilege of prosecuting for 5.5 years at the Legal Practitioner Disciplinary Committee of the Body of Benchers. The people that were brought there are not the major violators of our laws. Throughout the period that I was there, I only had the privilege of prosecuting only 2 senior advocates of Nigeria. And these 2 senior advocates of Nigeria, they both escaped, not because they didn't do what was wrong, but the rules we have is not even adequate enough to punish infractions of our rules. So if you talk about putting up advert now, like Prof spoke about advertisement, a lot of people will put up advertisement to attract briefs to the office, but their integrity to maintain efficient and effective legal services will be questioned by their monetary consideration. A lot of lawyers have a lot of briefs. You are supposed to be accountable, you are supposed to be responsible, you are supposed to feed your clients with some information. If you collect clients' money, you are supposed to return money to the clients. Majority of the cases I had at the Legal Practitioner Disciplinary Committee were lawyers who collect clients' money and work it. So I look at our integrity, I look at ourselves, and I say the major problem, if you look at the paper that I sent to you, is that the greatest enemy of the legal profession is the legal profession itself. And I'm a court-based lawyer. I go to court. Majority of us, what we do in court, the processes we file are not in the aid of justice. They are interested in defeating the end of justice. I look at our judges, and the majority of us who are courtroom lawyers, you will notice a lot of things that are happening in Nigeria today. Under our laws, certified through copy of public documents are admissible and they speak for themselves. But in our electoral jurisprudence of today, our apex court, the highest court of the land, has developed a principle or series of principles of law that are anti-justice. And a lot of us that go to court, not those who are commercial business lawyers, you discover today that 90% of judgments in our court are devoid of justice. 90%. They are devoid of justice. People are not interested in jurisprudential, jurisdictional judgments we get from our courts. You go to court. I give you an example. Yesterday, I was in the Supreme Court. That case at the trial court, judgment was delivered against my clients in 2000, the year 2000, on the basis of what they call public officer protection law. People were dismissed from their employment because they travel out for training, and they were dismissed. We went to court. The merit of the matter was not examined. What the lawyers on the other side came to court to say is that the action was caught up by public officer protection law, that we didn't go to court within 3 months. My Lord Justice Nyako, in February 2000, I agree. I went on appeal to the Court of Appeal. 2002, the Court of Appeal dismissed the appeal. I filed appeal to the Supreme Court 2002. That appeal was only heard yesterday, 20 years. And unfortunately for me, all my clients are in overseas. I receive insultive messages from them every day that what kind of justice system do we operate in Nigeria? So we go to court to argue on technicalities devoid of justice. And so do we have environment, we have character of lawyers who will overlook technicalities and say, let us look at the substance of the matter. Let me give you another example outside of my paper. This afternoon, a colleague called me. There was a young man who was selling building material. Air Force personnel, when they bought building materials, and then they use it and return it some few weeks. They say, look, they don't want it again. And the man said, look, I can't collect it because I've already rendered account to my master. They say, you must give us money. The next thing we heard and saw was that they came, picked him, and locked him up in the Air Force base for one week. After he came out, I said, okay, my office will take on the matter pro bono. We went to court, enforced his right. Judgment was awarded against the Air Force people for 1 million. Now they refused to pay. We went for garnishing proceeding. We were able to get 250,000 from a bank. And the Central Bank of Nigeria, who's supposed to give us the balance of the money, has briefed a senior advocate of Nigeria to go to court on the basis that the judgment debtor has filed an appeal against the garnishee order. How much? 750,000. And I told my colleague, don't encourage this. This is injustice. What is 750,000? So these are examples that you can get. And then when we come to our own professional association, which is called MBA, are we really, you see a lot of impunity in our elections, a lot of impunity. And Professor Juku talked about these rules of professional conduct 2007. I had consistently maintained that we don't have the rules of professional conduct 2007, because if we are to follow our rules and our law, then we must respect our laws, rule of law, and due process. Who issued the 2007 rules of professional conduct? It was the Attorney General of the Federation, not the General Counsel of the Bar. that was permitted under Section 12, subsection 4 of the Legal Practitioner Act to issue it. I remember in 2013, in MBA paper that I delivered in Calabar, I raised the point that if we are not very careful, one day somebody will wake up and do what the bar will not be happy about. Not too long ago, Malami came up to delete some portions from that law, and we all went to town. And I refused to be carried along by people who say Malami was wrong, because in the first place, we allow another Attorney General to issue the rules to us. Another Attorney General came and amended the rules. Because it's now detrimental to us, we are now crying blue murder. So as lawyers, we are also not integrity driven to point out what the law is, even if it's against us. So I look at that in my paper and I said, for me, the legal profession in Nigeria is not yet prepared for the changes that the technological innovation that Professor Duku eloquently spoken about is brought to bear in the legal profession. If we're talking about commercial law practice, for instance, look at the agreement of discourse. Because we also need a good environment with good technological and economical development for purposes of thriving legal business. You discover today that majority of our people who go into legal business with government, even in commercial ventures, are all thinking about their pockets, not you and I, how to be rich. And so I look at the get rich quick syndrome in my paper, and I say this is one of the factors that will also inhibit the changing environment that we're talking about in our legal practice. Because the next thing you want to be called is Chief Doctor Barrister Professor Okutepa with a chauffeur-driven card for doing nothing. And so in overseas where we are copying this legal practice from, lawyers are there with seriousness and respect our laws. There are laws there. You pay your tax, you don't cheat your colleagues. But today in this country, if you have the misfortune not to be a senior advocate, for instance, and you have a case with a senior advocate, ordinary arguments that may challenge the legal capacity of a senior advocate may land you in LPDC. And I have seen one like that when I was prosecuting there, because the clients were dissatisfied with the service of a senior advocate. They debriefed him, and the senior advocate wrote petition. And before you can say Jack Robinson, the young man was being brought from Lagos. I look at it and I say, what offense has he committed? I told the Legal Practitioner Disciplinary Committee that I've read the rules and I have not seen when it said that a senior advocate cannot be debriefed. People call me names, but I stood my ground and he was set off the hook. So the intimidating attitude of our colleagues even makes some young lawyers not to come out to say what they needed to say. If you look at our rules, the rules of professional conduct, Rule 1 to 55. Rule 55 says if you see wrong against anybody, make complaint. If you complain, they will decide your fate in bedroom. And so I look at our attitude, and my conclusion is that if we want to get good and follow the changing environment that is available for the legal profession in Nigeria, then we must heal ourselves. Our attitude, our characters, our behaviors, our respect for law and order must change. Otherwise, while the rest of the world will move ahead, Nigeria will go back to a 12th century attitude. And that is why our behavior is like Stone Age. If you go to court today, you see what judges do to you. Some of them are bully. Some of them. So when we talk about impunity, for instance, there is impunity in the legal profession. There is impunity on the bench. It is just because the executive is just too known. The impunity in Nigeria permeates every nook and cranny of the society, including religious cycle. So my conclusion so that I do not spend too much time, is that we need to have a change of attitude. That's number one. Two, we need to respect our laws and due process. Number three, the professional association that we have, with all respect, has lost its value to the society. The legal profession is supposed to be a profession of light. But in Nigeria, for instance, the legal profession, darkness has overtaken the legal profession. And in the gathering of Satan, it is absolutely impossible for one angel to make the difference. So we need to have the restoration of the light of the legal profession, the kind that will be the beacon of hope. Today, the NSAS ought to be led by Nigerian lawyers, but today it is being led with respect, and I mean no insult, by people who have no defined qualification. The legal profession that you and I belong to gives us a defined qualification. You see today, the judiciary is the whipping child among the three arms of government. Yet the judiciary is the only branch of government that has members with defined qualification. The other one, the executive, is secondary school, is equivalent. And its equivalent is to define to mean ability to read and write, or being in an establishment that is acceptable to INEC. You can't be a legal practitioner with secondary school is equivalent. That was gone in those days when from 1962, you must have to have LLB forms. Today, all of us here on this webinar, I believe, have LLB, and then we went to law school, we're taught, then we practiced law for a long time, but today nobody respects you and I, because the legal profession, which is supposed to be the light of the society, has allowed darkness overtaking it by what we do to ourselves, even in our own professional association. For the past 6 years or so, election to our professional association has been marred with irregularities of monumental proportion. And the leaders of the profession feel nothing wrong with the darkness that is hovering around us. We have allowed primordial partisan interest to overshadow our sense of justice. So, gentlemen, my conclusion, therefore, is that if we must take advantage of the changing environment brought about by technology and all of the issues that Professor Ojukwu talks about, then the legal profession must be restored to the light that it used to be, so that where light is, darkness will no longer comprehend. If that be the case, then the Nigerian society will fear and respect us, and then we'll have a lot of legal markets for both the young, the old, and then when you walk, no member of the legal profession will then put a spanner in the wheel of your professional fees, in the field of your money, and every one of us will enjoy the beauty of the profession. But until we change our character, well, we may just be talking about the changing environment in the darkness of Nigerian society. And the lawyers may soon be the worst for it. And I'm sure in the next 10 years, if we don't change our attitude and our orientation, the legal profession will go into extinction. I thank you for listening to me.
Thank you, sir.
Thank you, Leonard Silk, for such wonderful speech, for sharing your wealth of knowledge with us. Your speech revolved around the challenges in the changing environment and legal profession. And what I got from it is that, I'll put it this way: charity begins at home. We are our problem, and we are the ones that can change it and make it better. Thank you for that, Leonard Silk. Moving on, I shall call upon our next speaker. He is in a person of Mr. Atoyebi, SAN. I shall be reading briefly his profile. He is the youngest in the history of Nigeria to be elevated to the rank of Senior Advocates of Nigeria. he became a senior advocate of Nigeria in 2019 at the age of 34 and 11 years of his post-call. He is the managing partner of Omaplex Law Firm, a fellow of the Institute of Chartered Mediators and Conciliators. Mr. Atoyebi SAN, for reasons beyond his control, is unavailable today, but he is ably represented by Mrs. Onyinye Chikwendu Ikechebelu. Sorry about that. She is the practice manager of Omaplex Law Firm, and she will be presenting Mr. Atoyebi. Please, the floor is yours. Thank you.
Thank you very much. Good evening to everybody. Good evening to the Leonard Silks present, the Leonard Seniors present. I am humbled to be in this presence, and I bring you greetings from Leonard Silk himself. Unfortunately, he's unable to attend this meeting for several prearranged meetings, and so he asked me to extend his deepest and sincerest regrets. So, but I thank you all for having me, and I hope I can fill the very large shoes that I'm supposed to walk in. So I listened to Prof in his keynote address, and so many things he said. Someone like me, as young as I am, can relate, and as the SAN too, because the technological innovation in the legal profession is one key area, one core area the SAN is very passionate about. And so I'm just going to read his address so that I don't make a mistake. The shoes are way too wide for me. So since time immemorial, the legal practice has been and always will be regarded as the bedrock of the society. The role of law in social engineering cannot be downplayed, as it has over time saved the society from anarchy, lawlessness, and insurrection through the regulation of social relations, settlement, and resolution of disputes. The legal profession is one saddled with the responsibility of being the watchdog of the society. Hence, every legal practitioner should be unfettered in his resolve to be dynamic and should be ready to embrace the numerous changes that are bound to take place in the global space, mostly the disruption of technology and its application in legal practice. The legal practice in Nigeria has spanned over a century and is undoubtedly a profession characterized by nobility, integrity, and honor, as said by the Leonard Silk himself just previously on the integrity of the profession. And if I may add, it is one of the things that some of us saw and found the profession to be distinguished in itself because of its nobility and its integrity amongst fellow practitioners. And so some tenets and principles of the legal practice have been passed down from older generations, luckily, and of legal minds to younger generations. And some of these long-time principles have been adopted into the code and core of the profession. Even as our profession is one that reveres precedence and foregrounding, it is expedient that will open our minds to the realities of the new world and make conscious efforts to adapt and exploit the opportunities that the new wave of global advancement presents for the legal profession. In order to raise the bar and adapt to the changing environment, we need to focus on three key areas, which I believe are important and are essential to the development of legal practice. These areas include the emerging areas of law practice, the future of the bar, and ethics of the profession. The need to shift our priorities in the legal profession to focus on upcoming areas of practice, which happens to be very important in today's practice, cannot be overemphasized. The emerging practice areas are the future of the legal profession. With the rapid spread of digitization, there is bound to be a drastic shift from the normal. Areas of law such as intellectual property, financial technology, space law, data protection, competition law, mining law, blockchain and cryptocurrency, and other financial technologies. Currently, these areas are still in the budding stage in Nigerian legal system, and I believe that a searchlight should be shown on these areas in order to mine the gold that these areas have hidden underneath. I suggest that law firms and chambers diversify their practice areas and encourage the legal practitioners under their employ to make researches, write articles, and legal opinions on these areas so as to help spread knowledge and stimulate interest. Also, bodies like the Nigerian Bar Association can do a lot to kindle the interest of lawyers in this area through symposia, workshops, seminars, and conferences. This will help to familiarize interested lawyers with the intricacies of these emerging fields. If rapt attention is paid and the right resources channeled towards the progression from the mundane areas of law to the emerging areas of legal practice, I can ascertain that the legal practice is going to gain a lot of traction and move ahead faster than we can imagine. To the future of the bar, according to Judge Elliott, we cannot predict the future, but we can create it. The changing environment of the legal profession cannot be fully discussed without making due reference to the fact that every year, thousands of newbies are called to the bar, and the success of the legal profession in our motherland is predicated on the caliber of lawyers that we produce. The journey to success as a lawyer does not begin when one is addressed as a barrister or solicitor of the Supreme Court of Nigeria. It started from the moment the journey of the legal education began. The future of the Nigerian bar rests in the hands of the young lawyers and law students. They have the power to shape the course of the legal profession, and the quality of young lawyers and law students can either promote the nobility of the profession or smear it. Capacity building amongst young lawyers and law students should be widely encouraged and supported by the body of benches, the Nigerian Bar Association, law firms, and other relevant stakeholders within the legal profession. I implore the Law Students Association of Nigeria, LAWSAN, and the Young Lawyers Forum of the Nigerian Bar Association to invest time and resources into the development of their members so as to enable them to be familiarized with the nitty-gritty of the legal practice and encourage them to contribute positively to the development of the legal practice and profession. Also, the need for pupillage and mentoring cannot be overemphasized because it plays a key role in the development and growth of the young and budding lawyers. But if the future is secure, we can revel and bask in the present, and only then will we be fully prepared for the changing environment of our noble profession. The ethics of the profession. As ministers in the hallowed temple of justice, it is the lawyer's responsibility to defend and uphold the principles of equity, natural justice, and good conscience, in tandem with the laid down law. But even we as lawyers are not infallible, and hence the existence of the code, such as the rules of professional conduct, often at times due to a myriad of reasons ranging from greed to financial hardships to pressure from superior, we fall short of our ethos and that we are meant to follow and defend. There are high cases of corruption amongst lawyers, from undercutting to overcharging, and these practices are unhealthy for the legal practice. In order for us to sincerely raise the bar and attain the benchmark of excellence and world-class status we have set for ourselves, there must be strict adherence to the rules of professional conduct. More lawyers must value integrity above pecuniary benefits. The status quo is not the standard. It might not be possible to create a perfect legal profession free of retrogressive individuals and dishonest bedfellows, but we must make conscious effort to build a brave new bar we desire, because the change is not going to begin at the Federal Ministry of Justice or the Supreme Court. It's going to begin with us. To bring about the change we want to see is our individual and collective responsibility to contribute and work towards the growth of the bar, rather than undermining the efforts of those before us. Finally, change is inevitable, but one has to be ready to flow with the tide of change as it comes. The legal profession is excelling. It is our duty to be prepared for the differences that may result from their advancement and adapt so as not to be left behind by the music of change. The three areas I highlighted are pertinent to the future of the bar, and I believe with synergy and effort, the legal practice is yet to see its glory days. Thank you. In addition to all of that, though, I like to express a personal opinion on this topic. So recently, we just concluded the online virtual internship program for law students in the university, and some as young as in 200 level. And in our program, we highlight this, we took them through the boarding areas, data protection and privacy, mining law, space law, and all of that. And in all of these things, one of the most recurring anthem amongst them is that the schools that because of the classes they take, they're not familiar with any areas of law, of these kinds of practice areas, and they don't have the competency to be able to perform within that space. And so all their thoughts are the things that we were taught when we were in school some 10, 15, 20 years ago. And so when they graduate to the law school, they go through procedural courses and they are not taught these areas of law. So when they come out into practice and they have a firm that is into data protection or practices competition law, they have to go and start all over again as if they didn't go to school. And so you find lawyers who are not competent to give you the information. You can't rely on their research work because they haven't really covered a lot. And that shows that something is definitely lacking. Every time the bar wants to be raised up, we need to be able to have capacity to meet the new level. We cannot do the same thing that has been done since my mother went to school and expect the results to be different. There has to be systemic change within the training in the legal profession. Even as lawyers, I personally believe that technology is but a tool to achieve a desired goal. Not to say that the principles that we learn in contract, the principles that we learn in thought and all of that will be redundant. But there has to be there's a vehicle now through technology where we can achieve those things. And then the lawyers that operate within this space now, currently, have to be equipped with the knowledge to function in that area. So now that Paystack was bought, there's a lawyer that was involved in that transaction. And then that lawyer cannot, it will be negligence not to be competent enough to be able to know that level of that business area for their clients. So you have clients in different areas, in different industries, and then we as lawyers must be able to have the capacity to understand the business of the clients and then find new and innovative ways to add value, so that the only thing that we learn from the universities and from the law school will not be to come and go to courts and argue cases. And when that is done, when they ask us questions of a different industry area, we can't relate. My own personal story was when I finished from the law school, the only thing I knew was civil and criminal litigation. I didn't know anything outside in project finance. I didn't know anything in international trade. And so I just went and I did litigation for 5 years. And it was interesting. It was, I feel like every lawyer should pass through the court system. But that is not the only thing that is there. And once we don't open or allow people understand that there are other areas out there, we will ultimately be boxing them into a corner, and then they cannot function properly in a moving society. So we need lawyers who can talk about global warming. We need lawyers who can talk about the conversion from gas, from fuel to gas. We need lawyers who can be able to have conversations within that space and be fully knowledgeable about what they are saying. And I'm saying that for us to raise the bar, we need to reform our capacity training, even as lawyers who are called. We need to reform that. That is a major area that if nothing is fixed, I don't think we can innovate into anything else. And then if you want to use technology, you must first of all understand the space that your client is working in, and then find how technology can be useful in that space, so that lawyers can talk comfortably about technology in healthcare. We can talk comfortably about technology in agriculture, because technology is going to be a tool through every industry. But we as lawyers need to be able to have that conversation and have it confidently. And then even when I read a book one time and it says that a lawyer's work we are a service industry. So even when those clients don't come immediately, you need to build the capacity so that when they come and when they show up, you have the ability to converse and transact seamlessly. And so I hope that this conversation will be part of a larger conversation that will keep going on, so that we can find ways to make institutional changes and changes that are sustainable, so that it will not be after one generation, the whole conversation just goes back to the default mode of, and all of that. So I thank you for having me, and I'm floored. I'm deeply honored at the panel to which I'm speaking amongst, and I thank the SAM for even allowing me to do this. So I thank you all, but that's my presentation. Thank you.
Thank you very much for such insightful speech.
We thank the Leonard Silk, ably represented by Mrs. Chikwendu Ikeche Belu, for also elaborating on the Leonard Silk speech. What I can take away from that is that there is a need for a paradigm shift in learning, which is very important for us to actually position ourselves in the ever-changing environment of our legal profession. Thank you very much. Moving on, I shall be calling on our next speaker, Chief Akiola, to take the floor and share with us his wealth of knowledge. You're welcome, sir.
Thank you very much, and a good afternoon to everyone listening this evening. It's indeed a privilege to have been invited by Threshold attorneys and solicitors to speak at this webinar, to share, and of course, with our learned colleagues all over to share um, our thoughts on the theme for the webinar. The paper which I want to speak to seeks to explain the benefits of technology in law practice. We dwell on globalization, institutionalization of law firms, the emerging trends in the legal services industry, practical skills and tools needed for lawyers and law firms to improve their practice. And I'll start with technology and law practice. The theme for this webinar is very apt, given the importance and future of the legal profession amidst a rapidly changing world driven by fast-paced technological innovations and increasing external competition in a highly globalized world. Over the decades, major changes leading to the 21st century have revolutionized our ways of life. But the center of it all has been based on technology. The impact of technology is notable. And if the legal profession in Nigeria refuses to incorporate technology in its practice of law, it will likely lose its relevance in its fast unfolding future. For greater productivity, it is necessary for lawyers to understand the language of technology, knowing and adopting several number of technological tools and software that can be deployed to perform certain legal services. The legal profession has undergone various transformations and evolved to the present state with the enormous impact of technology. Technology in itself has changed the narrative of the legal profession, has already been witnessed in some foreign countries and also locally here in Nigeria. We've also witnessed new entrants of other professions as the legal processes in some jurisdictions are now being digitalized. In a world where information is now accessible by everyone through the internet, of greater concern is the use of such information. Law firms in some jurisdictions are no longer only owned by lawyers, as they've opened up for public investment to encourage transparency and openness. I know that in Nigeria, we still try to follow the old norm, where we guard the practice of the law and we frown greatly at anybody having incursions into the practice of the law. In the developed climes, you have people seeing the practice of law simply as an investment. You have people that have access to money come together, and then they pool, resources together and get the best of legal minds. And of course, the lawyers will run the practice, but then what you have is some people looking at the practice of law as a strict business, and they operate it as such. As such, a legal profession is not only a profession, but also a business. Consequently, new professions with different job specifications are evolved in the legal industry. For instance, law firms now have teams of legal engineers, legal architects, legal designers, and so on and so forth. Similarly, the expectations of clients have gone beyond just requesting for legal services, but for legal practitioners to also offer services such as business advice, risk management advice, financial advice, and so on and so forth. The current global legal market is increasingly driven by technology, and any lawyer that fails to adopt technology as an essential tool will be left behind while the rest of the society will surely move on. And this is certainly not good for the legal profession in Nigeria. Different to what obtains in the legal industry of other jurisdictions, few Nigerian law firms have embraced technology generally prior to COVID-19 outbreak. And if truth be told, COVID-19 caught large numbers of law firms and lawyers in Nigeria most unprepared. But thank God, despite the pandemic, I think a lot of lawyers have now evolved a greater means of communicating with themselves, training with themselves, and exchanging training programs, and having greater impact in the practice of law. As you know, in the field of arbitration, long before now, the arbitrators have been used to this mode of training. You have online training, you have online teaching programs that are generally being disseminated. But as I said, this pandemic has been able to bring to fore the need for everybody to be more responsive to technological needs and to be able to lay their hands on it, to be able to make and have better command of their respective practices. Demand for legal services internally and externally are increasingly multinational companies whose interests cut across national borders often refer the services of the elite law firms with transnational status to handle the diverse global projects. These transnational fields of professional services require huge shifts from the traditional practice common in Nigeria. Examples of such services include international arbitration, as I mentioned earlier, corporate restructuring, project financing, and so on and so forth. At a time like this, where fiscal meetings are not the norm, hitherto, this program is organized by Threshold would have had to command physical attendance. But here we are having a virtual meeting, and from different parts of the world, different parts of the country, people are able to take part and knowledge is being able to be shared amongst all present. Technology is significant in arbitration and court proceedings. In arbitration, digitalization enhances distinctive qualities as a dispute resolution method, particularly in areas of cost time efficiency. Of course, the Chartered Institute of Arbitrators, as I told you, of which by God's grace, I happen to be the first vice chairman, have launched so many digital platforms. And interestingly, our director of training is equally a panelist at this webinar, and that's in the person of Mrs. Obosa Akpata. I'm sure in our presentation, she will let you know the extent. If she's not added that to our presentation, she probably will let you know into how much work has gone into that, and even let you know that since the pandemic, she's been able to make a far greater impact on would-be practitioners in the field of arbitration than hitherto, when all were limited to having physical meetings. Now, there are some other emerging areas of the law that, of course, I would want to dwell upon. Being a lawyer means many things, but the most paramount is that you are considered a learned fellow. Everybody expects you to be an expert in everything. What business are we in? The answer to this question may no longer be a simple one for many lawyers and the firms in which they work. Most lawyers today find that traditional definitions of lawyering no longer fit either their own activities or the demands that their clients place upon them. The law has always boasted of being the most diverse profession, which moves with time, changes the growth and reforms in every single way necessary, in tune with generations. The law survives such as with demand. The demand for reformation of existing laws and the introduction of new ones is an essential as an advancement and development, because inadvertently, or sorry, advertently, they do go hand in hand. I mean, because of the dynamic nature of the practice of law. Every day, the world discovers something new. Every day, new point of dispute or contractual discipline emerges. So every day, there's a need for binding rules to regulate such dealings within the ambit of the law. Furthermore, the law has no choice really than to progress along with the world, because not only will there be a bundle of new era legal programming, clients are also bound to come with new generational cases, the solution of which lies solely on making provisions to tackle those issues as against the discretion of very many judges as they deem fit. The Nigerian legal landscape is facing changes in its service delivery models and expanding fields of practice. There are factors propelling the emergence of this diversified field of legal services. They are based on technology, on globalization, and of course, economic diversification. Some of the fields, emerging fields of practice in the legal profession developed or influenced by technology, globalization, and economic diversifications are corporate and commercial law firms, which is what a lot of people do these days. You have a lot of law firms dwelling on taxation. You have a lot of them dwelling on ADR. And I bet a lot of people see ADR now really as the norm. Everybody wants to run away from the courts. The dockets of the courts are so full. For instance, we're in October. I can tell you that maybe for this year, the courts probably in all totality have not been able to have functional operation for more than 60 days. And this is the 10th month of the year, because as early as late February, March, the pandemic started, and it slowed down everything. There was total lockdown. And just about now, when things were about picking up, then you have the end SARS protestation, which again has devolved into the hoodlums taking charge and hell being let loose, which again has led to great losses for the legal profession, I must say, because from what we've heard, the magistrate court, the high court, and the Court of Appeal, Lagos, were greatly impacted yesterday, and parts of the high court was burnt. Only God knows the extent of the damage that would have been occasioned by the impact of the hoodlums. I know for a fact that it's not the NSAS protest that led to all this, but the curfew that was imposed left a lot of porosity for hoodlums to operate, and the end game is not being good. We don't know the extent yet, but this again brings home the need for technology, because assuming our dockets are being digitalized, I'm sure it really would take not more than having a week of recopying notes, recopying files, and the system will start to run. Only God knows where we will pick from, where we'll start from once the setting gets cleared. Again, we have entertainment and media law, amongst all others, not to talk about oil and gas and other specialized fields, entertainment law, sports, people are going into sports law, media law, and so on and so forth. Reasons for the low participation of lawyers in the emerging fields of law could be seen as premised on the fact that most lawyers still get focused. They focus their mind on the traditional mode of practice. And as Professor Ojukwu said earlier, and I think this again was brought home by the learned Samuel Okutepa, you find that a lot of young lawyers, they still run through the old mode of practice. And I think it was Professor Ojukwu that mentioned the fact that indeed, younger lawyers deserve to advertise more than anybody else. But alas, they're not looking in that direction. It's not due to their fault. It's the fact that the old order maintains that lawyers should not advertise. But of course, with the rules haven't been revised and opportunities open, I think people should take advantage of what is the norm now. There is a new norm. Just as COVID-19 pandemic has brought a new order, I think even in the practice of law, there must be a new order, and every lawyer, be you an old lawyer or a young lawyer, we should take advantage of the situation in which we have found ourselves and make the best of it. In conclusion, this paper has shown clearly the realities of technology, globalization, and emerging fields of law, and I submit that lawyers must do the needful by embracing technology and ensuring that this becomes the new norm going forward. Thank you very much for listening, and I hope I've been able to make some little sense in the little minutes of my presentation. Thank you.
Thank you, Chief Akinola. And I must say that you have made a whole lot of sense, not just little, in adding to today's discussion. My takeaway is that technology is critical in our legal profession to enable us provide top-notch legal services and to compete in the, at the international space, and to also cater for international global demand. Next on our panel, I shall be calling on Mrs. Obusa Apata to share with us her thoughts today. Thank you. Well, welcome, ma.
Thank you very much, Jude. Hello once again to all the panelists and everyone listening in. Interesting topic. When the Leonard Silk was speaking, I must confess I worried a bit for the young lawyers because he clearly painted a sincerely bleak and unfortunately truthful picture of the legal profession in Nigeria today. But to say, please do not lose hope. We are part of a global society and we have to forge ahead. So we are hoping that this discourse, amongst many others, hopefully you have been part of, will encourage you to do the retooling and the upskilling you need to do to make progress. Today, I decided I'll be speaking on upskilling for impact in alternative dispute resolution. A lot has been said, which is really true. I noted Prof talked about an avalanche of career paths available to be explored by lawyers. In Nigeria, indeed, we get the impression that the legal profession is overpopulated, that there are too many lawyers, and then, of course, this leads to other issues such as poor pay and all of that. Be that as it may, what has been pointed out thus far is the fact that possibly lawyers are not looking at the wide variety of opportunities that surround them. It could be for a lot of reasons. The Leonard Silk talked about a lack of adequate infrastructure, which we're all aware of. But I think, the purpose of platforms and discussions such as we're having today is to encourage particularly the young ones to think, wide and far, to venture outside the box as they have known it. Now, we have talked about the evolution of the legal profession, and I'll just very quickly like to take our minds back to the introduction of ADR into the administration of justice, so to speak. Now, following the judicial reform which commenced in 1990, following the return to democratic rule, the resolution of commercial disputes started, with the use of ADR processes, with the aid of mediation, right? And I'm using Lagos State as a point of contact in this discourse. Now, it started with, or was introduced, the use of mediation was introduced with the creation of the Citizens Mediation Centers. Subsequently, in 2002, the introduction of the multi-door courthouse revolutionized ADR, alternative dispute resolution, particularly arbitration and mediation, by integrating them into the regular court system. Now, since then, you have the Citizens Mediation Centers being replicated in 16 other states. You have the multi-door court system being replicated in 14 states and the Federal Capital Territory. Now, the point I am making with this is that once upon a time, that was some form of new innovation, so to speak. But today, like Chief Akinola said when he spoke earlier, it is the norm. And that is really how it, it works. Now, like William Blake said, what is now proved was once only imagined. So this is also encouraging the young ones again, that there are opportunities out there. There are different, aspects of legal practice that you should be looking into. Onye mentioned quite a number and talked about the fact that even when they reach out to students, they express the fact that they don't know, a lot of, the areas of legal practice that they're being introduced to. Now, with the aid of training provided by, in some cases with the help of the government and the various institutions, such as the Chartered Institute of Arbitrators, which I currently head the training committee on, there's no question, because I'm aware, just like Chief said, the efforts we have put in to educating from students to lawyers to legal practitioners to non-lawyers, because arbitration is really not limited to legal practitioners. Now, a lot of effort has been put in conjunction in some cases with other institutions, the Lagos Court of Arbitration. I'm aware of the Lagos Chamber of Commerce for International Arbitration Center. A lot of effort has been put in to educate, anyone who's interested in alternative dispute resolution. Notably, like I said, arbitration and mediation, because they're the most conversant mechanisms in Nigeria. Now, we talk about raising the bar. I have to be fair to the NBA, to the Nigerian Bar Association, because I am aware. I currently head the committee on arbitration and ADR, of the section on business law. So I know the efforts, again, we have put in trying to reach out, as far as, to places in far-flung areas, I know Warri isn't far-flung, but efforts have been made, to reach out to lawyers, and then bring these trainings, make them as available to them as is possible with all the challenges we have, with travel and all of that. So efforts really have been made, and I think are being made, to create the necessary understanding and, to make available to members of the legal profession the relevant training to enable them compete or at least participate in the provision of legal service as it ought to be. Now, we talk about raising the bar. There's a need for a change in approach. Now, when we even talk about arbitration and mediation, yes, today we say it is the norm. which is the truth, and lawyers are pretty aware of it. These processes, as we know them, have come in to bear to help decongest the courts. More importantly, just effectively and efficiently resolve disputes. These are services. So, and when you look at the characteristics of these mechanisms, you will find that particularly with reference to mediation, it's really more of a win-win situation. And then when we talk about arbitration, I'm talking from experience. Even at that, it can be, and it sometimes is, a win-win situation because of the way the processes are designed. Parties are able to then appreciate their respective positions and very often conclude the arbitration but part as friends. And that's the whole idea. Now, whilst ADRO is now being seen as the norm in today's, as part of the dispute resolution mechanisms available, including litigation, we have the attitude of lawyers, unfortunately, being a bit more litigious than it should be, even when they get involved in these processes. That in itself is a hindrance. And that's what we're talking about. Now, so when we talk about raising the bar, therefore, you're talking about, lawyers not taking advantage of loopholes or even deliberately creating loopholes to challenge awards, to contest settlement agreements. I mean, because it makes it really unwholesome. Now, also the failure and reluctance of lawyers to then acquire the requisite skills to cope, to participate, to efficiently provide services in these spaces, calls for, it's unfortunate considering that we've had these processes with us for over 2 decades now. So it's not the way to go. And I think that's one thing we should take away from here. Now, aside from that, the irony is, and this is to show you the importance of continuous education. I think that has been repeated here by the various speakers. When we talk with respect to ADR, even for those who have acquired the requisite skills, there is a need to continue upskilling. It's mandatory, it's just part of life. It's part of being the competent professional that we are supposed to be. This has been showcased recently in the, following the impact of the COVID-19 pandemic on the different sectors of human existence, including dispute resolution. Now, there were government-imposed restrictions on movement in a bid to contain the spread of the virus. And this led to a need for more digitalized dispute resolution processes. And that is the kind of wake-up call we all need. ADRO institutions all over the world were quick to adapt. Yes, we understand that they probably have better infrastructure. They were ready anyway because they may have considered, or had the opportunity to review some of these issues, maybe because they had a mix of some of these processes in the past. But by and large, we all know that even in international commercial arbitration, and that's why people also talk about the cost of arbitration, it involves a lot. Like Chief said, if we were having this webinar in the past, we'll be having it physically. Now, there are those who may have had to travel from out of town. Those are all costs. Travel cost, hotel cost, cost of time and resources, cost of the venue and things like that. But in the light of these restrictions in movement, we had to think outside the box. Quite a number of institutions, a good number of the arbitral and mediation institutions the world over have, proactively drawn up guidelines for virtual proceedings. Chief referred to it earlier on. One of them is the Chartered Institute of Arbitrators Guidelines for Virtual and Remote Hearings. And there are a few others, the African Arbitration Academy Protocol on Virtual Hearings in Africa, the ICCA Protocol on Cybersecurity. The bottom line is there was a need, an urgent need to adapt to the change that befell the entire world. And that is what that continuous growth and continuous innovation is about. This will, of course, require appropriate investment, no doubt. But the truth is, we are part of a global network. We cannot isolate ourselves. And so it is important that right now, when we talk about ADR, we're shifting even from the traditional way of providing that service to a more virtually based process of doing so. ADR institutions have had to come up with online processes for arbitration and mediation to ensure that the proceedings are able to go on. Now, with the restrictions on the physical meetings, these processes have had to rely on the use of technology. A lot has also been said. I noted the emphasis on the need for investment in technology, on the need to acquire technological skill set. It is the reality of our time, and it is the reality of today. And so when there's no doubt that when we then look at institutions which have revised their procedural rules and issued guidelines to provide for more robust provisions that allow for online processes, they have again created, these are new avenues even for young lawyers to look at. And I must commend lawyers, particularly the young lawyers involved in arbitration, and mediation, who are members of the Chartered Institute of Arbitration. I have seen them very, very quickly adapt to these changes, exhibit understanding of it, and that is the whole idea. It cannot be, as the legal practice continues to evolve, there is an obvious need to ensure that you prepare to evolve with it, that you are in the forefront or you are participating in the change that is mandatory. I do recall that a few years ago, people like me, I'm from the older generation, but people like me had issues with AI, artificial intelligence. It was a case of, my goodness, what is all this about? It took quite a bit to get an understanding of how technology in that sense, is applied to the services we provide, to the processes we have to deal with. And ironically, the more we acquire that understanding, that skill set, the more we actually appreciate the benefits of this technological integration into our services. So like the previous speakers have said, and I think Chief Akinola emphasized on it quite a bit, there is no running away from it. Those are some of the possibly reskilling we will need to acquire if we had no idea of those kinds of skills. For those of us who had some idea, then we will need to upskill in that regard. Now, he mentioned very briefly digitalization. That's what we've had to face in arbitration and mediation processes, having to take your documentation from hard copy to soft copies only. And of course, these will also lead to the kind of issues that will arise. And one of them is cybersecurity. So if you don't even have that kind of understanding, where do you start from? What of those who are involved in these processes, be it as mediators or as arbitrators or even counsel? You need to upskill to have that understanding, because what has been done is that the world has moved on to create ways by which we can actually utilize technology to ensure that we continue to provide the services, and not just provide them, but provide them hopefully even cheaper, clearly more effectively and more efficiently. Now, arbitration, like I said earlier on, these institutions, these ADRO institutions, have revised their procedural rules and issued guidelines to provide for more robust provisions to allow for online processes. And these, of course, have led to an increased digitalization of information, which is the truth. So in some cases, you have institutions that are generally discussed, and this had to be done during the pandemic anyway. Hard copy documents were totally discouraged. They were not encouraged at all, because that was a very good way of spreading the virus that the entire world was trying to contain. So of course you had to come up with platforms that manage that provide case management services to you. You had to come up with platforms that provide virtual hearing services. And the important thing is, how do you participate? How, for instance, would you, in the process of going through say mediation or an arbitration, now stall it for how many months, simply because parties cannot get past the mindset of a physical meeting? It's not done because other options have been raised. And these are some of the reasons why training is essential. And I must encourage young lawyers, as much as the NBA and the various sections and even the educational reform required is looked into, pending when all those come to be, there are always ways of training yourselves. One of your greatest attributes here in this day and age is Google. Google is your friend. You get a lot of information on Google. So if it's a financial issue, then so be it. But besides that, you also have, in some cases, in fact, in recent times, I'm hoping a lot of young people went on the webinars that were offered, free of charge, practically on a daily basis on different subject matters, because they would have educated themselves immensely. Now we talk about things like case management tools. We talk about the various platforms, like I said earlier on. Now, because what has happened is that a lot of the institutions have revised, their procedural rules, or in some cases, issued guidelines, on what I would call a virtual proceedings or virtual hearings, to create an adequate environment, where parties are guided in the use of these processes. Now, when I would just very briefly like to tell you just a little bit about them, and this is to also encourage the interest, in the new changes that have come to bear in the light of the pandemic and the restrictions. So, for instance, you have the various platforms. There are a wide range of platforms. That's the truth. Then you have the various platforms available, and you do need an understanding of how these platforms work to even be able to identify what suits you, what is adequate. I remember at the beginning of the lockdown, when a lot of us had to then start, in fact, WhatsApp was no longer only for just chats and calls. We learned to use them for meetings and all that. And even people like me, who I felt, okay, I wasn't as quick, when it came to being digitally savvy, could appreciate that WhatsApp had an end-to-end encryption when at that time Zoom did not. So you can imagine if one was involved in an arbitration and you think to yourself, Zoom came across as more professional, there's a lot you can do with Zoom, the breakout rooms and all of that. But it was not encrypted. But even I could identify that. I know shortly after that, they clearly got the end-to-end encryption, so which makes them a fantastic platform now, I would say. But there are a number of these things. And all we need to do is get interested sufficiently to find out about them. And at this point, I would like to tell you that indeed, just like Chief Akiola said earlier on, the Chartered Institute of Arbitrators Nigeria branch has actually put in a lot of efforts to bring in this training to anyone interested, because they are held virtually, it's not even limited to Nigerians. And we actually do have participants from far and wide, from as far as the US to India and to a host of other countries. But the whole idea is the CIAB has designed this certification training, to offer tailor-made solution of qualitative development of essential competence in the use of technology. And you all need it. Everyone who's interested in it, because that is where we are headed. Now, these trainings, of course, if you go online, we have a very responsive and informative, website. You will get all the information you need. They are actually masterclass online dispute resolution, courses, for dispute resolutions, international and domestic arbitration, and for mediation as well. In fact, with mediation, it includes both resolution in commercial and family mediation. And that's just to tell you some of the efforts organizations are putting into bringing training the way of our young lawyers. We cannot continue to hear, the lawyers are not equipped to participate, in the current, ways of doing things. It's just not acceptable anymore. Now, you would also find out that now what we then have, and this is telling, trying to make the point about innovation, is that where ADR has become the norm, we now have a situation where even the traditional ways of providing dispute resolution services under mediation or arbitration have been impacted. So we have quite a great deal of integration or conversion into what we call online dispute resolution. Online dispute resolution in the past were really for e-commerce based transactions or disputes that emanate from e-commerce based transactions. Now I look at that, and even in looking at it, and I talk to myself, this is where even as lawyers, we need to appreciate that indeed there is a pretty wide parameter for various opportunities. Because when we talk about e-commerce is relatively new in Nigeria, even worldwide. When we say relatively new, maybe started in the last decade or so, because you're talking about where a lot of us now order stuff on Jumai, Konga, we use, we talked about, Onye mentioned Paystack the other time, so now there is a lot of e-commerce based transactions. And online dispute resolution is actually utilized in the past, was more like developed to address disputes arising from these, e-commerce transactions. But now, what has happened is that a lot of the techniques in online dispute resolution have been adopted into the traditional way of doing ADR, of providing those services in ADR. So where normally you would say, oh, naturally your preliminary meeting, you will sit together, all those are changing. Now, by, even by emails, sending questionnaires, getting it back from the parties, you are dealing with preliminary issues immediately. And probably leaving your physical meetings to when you meet, to your hearing. But even at that now, of course, we are beginning to infuse, video conferencing. With the aid of video conferencing facilities and all that, we're beginning to infuse what we call virtual hearing, which is carried out on quite a number of the various platforms that now provide these services, from Opus to, there are quite a number of them, to Zoom, to WebEx, to Google Meet, and things like that. So it just gives you an idea that indeed, something else I came across, for instance, e-commerce companies like eBay, Alibaba, Amazon have adopted ODR as their tool to settle their consumer-to-consumer disputes on their platforms. So here again, it's only a matter of time before we have the likes of Jumai, Konga, Payport, and the likes doing the same. That's my belief. And I think I am right, if we go by antecedents. So you look at all this and, it should encourage young lawyers that indeed there are wide and varied opportunities out there, and it's also encouraging encouraging to see that at least the judiciary is trying, to pick up, because these are processes that still need court support, like I like to point out. But so they are making an effort to also adapt to the changes so that, by and large, they can provide the support that these processes require. I think what we need to take away more than anything else, there's no doubt we have quite a number of challenges, because I know I wouldn't be surprised if somebody says, oh, what about when you get an award, enforcement of an award? I keep saying it, to a large extent, there is no doubt that you will have parties and counsel who will take advantage of the slow pace of judicial enforcement in Nigeria, but that's because that is available. Because the world over, you still have parties who will challenge awards, very likely for good reason, or within the parameters provided statutorily for them to do so, and things like that. And there's no problem with that. It is when it is done with the wrong mindset. It is when a lawyer decides to look for a reason. I think the learned LCN gave an example of his colleague who he had to speak to say, really, you want to go on appeal because of 750,000, things like that. So it's the mindset. We have to work on our mindset. There must be a willingness to appreciate that the legal profession is a profession, where service is required and is provided. We are reminded always that we are ministers in the temple of justice. It must be with the right desire, to provide a service and provide it competently, effectively, and efficiently. And to do that, you've got to keep upskilling. Thank you.
Thank you, Mrs. Obosa Apata, for such wonderful speech from you. What I take away is that there's a need, and which you repeated in your speech, there's a need for us lawyers to continue upskilling, especially in the area of alternative dispute resolution, ADR. This is because alternative dispute resolution is no longer simply an emerging practice, but increasingly becoming the norm. And more importantly, training for this area of law has now, readily become available. Thank you very much for taking the time to share with us your knowledge. I shall be handing over to my co-moderator, Mr. Fernandez Obiene, to take over from me. Thank you.
Thank you, Nodum. Well, I've learned a lot today. I'm happy I'm here. So the next person, thank you very much, Ms. Apata. The next person I'm calling is, well, I told you before, is my Ms. Apata. Well, she's my madam, but she doesn't know yet. The next person I'm calling knows that he's my Oga. In fact, recently I've been seeing his pictures in a number of places. I've been seeing him everywhere. He's a former secretary of the Lagos branch of the Nigerian Bar Association and a close friend of mine, close senior friend of mine, because now he's an old man. Please welcome Ikechukwu Wana.
Thank you, Fernandez. That was a good one, that I'm an old man. Thank you, everybody who has actually stayed up to this time. It's a very difficult time for everybody who lives around Lagos, considering the security situation. Spending over 2 hours on your data, listening to speakers and learning, it's not an easy one right now. I think it's a luxury. So I really want to appreciate both the panelists and the persons who have come on to attend this session. The good thing about speaking last, when you have such an erudite panel and keynote speaker, is that what you'll be doing is basically to rehash what has been well said, and also basically to just take your time to just draw a conclusion. So I think my work will be easy this evening, because I'll just be merely concluding on what the very learned seniors here and my colleagues have done justice to. But before I go into that, let me thank threshold attorneys and solicitors for putting together this and not shifting it as well. I think it's a harvest of a lot of ideas and knowledge that would, I'm sure would help each and every one of us who have been here all day. Thank you very much, Threshold Attorneys, for doing so. When I was preparing, my idea when I was preparing for this webinar was to speak on the rules of professional conduct, basically how they've become what I would say challenges, or what I would say stronghold for lawyers to progress, or participate in the new and emerging areas. But you would all agree with me that Professor Ernest Ojukwu had ably done well in his paper, in his keynote speech, trying to address a number of the issues, a number of which I had even raised. But quickly, I want to just touch on a few of them. And then I'll talk about the vehicles we use in practicing law briefly. And I'll just summarize with what I call finding your niche. All of these things have been said earlier on. On the issue of rules, like I said earlier, Professor Chukwu has spoken to a number of these issues that I just want to specifically touch on. The first would be the Rule 51 of the Rules of Professional Conduct for Legal Practitioners 2007, which talks about funding of litigation. I had thought about speaking about it because a lot of the litigation matters, and he pointed us to the maybe an oil spill matter and all of those kind of things. The truth about it is that it is not exactly allowed in our rules of professional conduct, but I think that lawyers need to find a way around it, around a number of these things, and that's what Prof was just speaking to in his keynote address. The law profession and the economies that drive it has become quite sophisticated that we as lawyers need to find ways and means to ensure that we meet the obligation to the society, one, meet the obligation to our clients, and also are able to, advance our cause as businessmen. Because we're not just lawyers, we're also running businesses as well. So it's important that we find a way that if it's a matter that needs to be, you need to get experts, like he pointed out, and do all of those things to ensure that the matter goes on. We need to find ways and means to go around it, not circumvent, but find a way of avoiding the rules to ensure that we're able to serve the needs of justice. Also, he talked about consortium, and he mentioned AMCON when he was talking about consortium. My law firm had been a leader in one of those teams that AMCON requested that we put together to serve them some years ago. And they insisted that you must have an estate management firm in your consortium. They insisted you needed to have an accountant. They insisted you needed to have, I think, someone who is good in tracing assets, like a security personnel. The rules of professional conduct, and I think that's Rule 53, says you cannot share your fees with other persons or even work in consulting with other professionals. And it was a difficult one. But the truth about it is that if you must practice law in the 21st century, these are things that you must find a way around it. And I think that right now that we're having issues with our rules, like Mr. Okutuba, Jubril Okutuba, SAN rightly said earlier on, we need to find a way to have a total overhaul of those rules, our rules of professional conduct, and make sure that they're in tandem with 21st century requirements for one to practice law. And also so that we can practice law in a manner that we're not just looking for ways to avoid the rules, but we're even focused on delivering the service to the society and delivering services to clients. And then the issue of advertisements, which is in somewhere between 46 and 49. And Prof did not exactly speak to the five ingredients on advertisement and all of that. That's something that I would have loved to hear him speak to, because it's also a learning process for me as well. But the truth about it is that looking at the entire rules of professional conduct, and if you interpret it in a manner that is non-liberal, I suspect and I strongly believe that you may not, as a practitioner, you may not be even allowed to have a website. And that's my personal view. That's my personal view. The truth is that the world has evolved, and it speaks directly to your having a signboard. But 80% of the law firms, for instance, in Lagos do not have signboards, if not 90%. 80% of the young lawyers who I know today do not even have a signboard in their offices. Many lawyers do not have signboards, but it says nothing about having a website. And I think that we should look at means and ways to, ensure that we reform our rules of engagement. The rules of professional conduct is what basically guides lawyers in their activities. And my good feeling is that I don't think it serves the purpose of any lawyer not to talk about young lawyers today. Yes, Professor Juku had stated a number of ways we could do things, writing articles on LinkedIn and all of that. But beyond all of that, when you look at some ranking platforms and directories, you see that what they also state, like you go to Chambers and Partners that rank Nigerian lawyers every now and again, what they speak to, to my mind, the way they publicize those lawyers or publicize us are things that are not compatible with our rules of professional conduct. So I really think that we need to take another look at our rules of professional conduct, especially at this time when it's under scrutiny because of what the Honorable Attorney General of the Federation has done recently, and see how we can develop a rule that will serve better purpose of every Nigerian lawyer going forward. Now, let me quickly go to the second aspect of my presentation, and this will not be long at all. Like I said, it's a conclusion that I'm trying to bring to what people have already spoken to earlier on today. So I'll try to make it as short as possible. The vehicle we use in practicing law. Prof also spoke to this to an extent. Mr. Okutuba SAN also spoke to it a bit. The law profession has gotten to a profession where one person can run a law firm, so to speak. Law firms are now is a more complex and sophisticated business. So we need to start looking at how we can have more partnership, more arrangements, even if it's not a partnership, that would bring a lot of skill sets on the table for the services of clients. The vehicles vary, and whatever works. When Jubril Ketuba SAN was speaking, he said that we don't trust ourselves. But in the whole world, I think it's not just limited to Africa. Everywhere in the world, people do not trust themselves. But I think we should learn to use documents, use those documents and instruments that the law has availed to us to ensure that we are able to build enduring legal structures that will serve us and serve our clients. More and more, the environment of today, because we are speaking about the changing environment for legal practitioners in Nigeria. I think it has changed a lot. So I don't see how one lawyer can effectively do litigation, effectively being the operative word here, effectively do litigation, do a commercial work, and maybe come and also do oil and gas, and is also doing maybe company secretarial. That time has come and gone. I think we need to look, and the clients have become more demanding, they become more savvy. So the expectation of the legal profession and the legal practitioners are quite high. So I think we need to look forward to a situation where we build structures that enable us bringing people with different skill sets that would help us run better law. That's about vehicles in practicing law. And I think just to close it by saying that we need the right vehicle to run in the legal profession. If not, it will be quite difficult. And then on the issue of finding your niche, Mrs. Onye had spoken a bit about that, and a number of other speakers. The legal profession now demands specialization, and there are a lot of emerging areas. A lot of those emerging areas we've gotten to that point where those areas have come around because of technology. And one that I want to just speak a bit about is data protection. NIDA, the Nigerian Technology Agency, Development Agency, recently, I think in 2019 or 2018, produced a guideline that insists that every company must have, or most companies would have their data protection framework, and would also have to audit those frameworks every year. That has opened a major vista for lawyers and other practitioners. And it's something that I still don't see a lot of lawyers playing in that field. It's something that I really think most of us should go and upskill and find ways and means to play in that area. A number of other areas like fintech. Fintech is something that a lot of people are talking about today. Recently, I think sometime this week, I heard somebody in one of the big law firms talking about that their fintech department, the main person has left to go and do master's somewhere abroad. And they are looking for a fintech lawyer. But there are many lawyers walking around the street and they're looking for job. But because they don't have an idea what fintech is all about and how they can play in the fintech space and how they can advise even the fintech businesses, we're not able to tap into those skills. So I think it's high time that a number of us start looking at those kind of emerging areas and see how we can play in it. Mrs. Zapata mentioned to us AI. There are a lot of legal issues around AI, artificial intelligence. That's something that, if lawyers can pay attention, especially in Nigeria too, they can actually be the trailblazers in those areas. And she also mentioned about Google being a place that we can all learn a lot of one or two things from. But beyond Google, we also have Coursera, all those online platforms that teach people a lot of things. And most of those courses are free or very minimal fees. So I want to encourage us to find our niche. What is that niche? What is that practice area that you can develop and even be the trailblazer in that area? The truth about it is that I may not be as old as some lawyers who have spoken before me, but also I'm not as young as Fernandez. But the truth about it is that there are a lot of things that I am not able to do that the Fernandezes of this world would be able to do. I mean, talking to young lawyers now. And it's a challenge for all of us to go back, find our niche. We can't be everywhere. We can't be running around courts for litigation. Yes, litigation is good. I still do litigation work. But there are a lot of areas where they are like blue oceans that we can explore. Can we go to those areas? People talk about corporate governance audits. Can we even learn what corporate governance audit is all about? Most companies have to do corporate governance audit every year. Can we be the ones that will do it for those companies? It doesn't just help us run our own law practices, but it also helps us to participate in our law firms. Onye, when she was talked about people not being able to participate when they came on internships and all of that, and how she had to relearn. Maybe if we start now, when we now get to work in other law firms, we may have a niche area that we're even being employed to just come and run. So these are my thoughts, which I felt I should share today. They've been short. And like I said, it's been an opportunity for me. It's been a great opportunity for me to do a conclusion for a lot of the very seniors who have well laid out their thoughts earlier on. Thank you so much. I'm very grateful.
Thank you very much, Mr. Awana. Don't go away yet. Don't go away yet. There's a question, and because you are the former secretary of the Lagos branch of the Nigerian Bar Association, I'm going to ask you this question. The question is from Professor Bankole Shotipo. It says, in what ways can the NBA ensure that lawyers grow increasing relevance in emerging sectors of our economy that have grown without attendant use of legal services?
Okay, thank you, Fernandez, and no thanks for putting me on the spot. Mrs. Zapata has been much more involved in the NBA Lagos branch, and I'm sure she would have done justice to this. Anyway,
okay.
I'll still try my bit, and I'm sure she will come in if I've missed it in any way. Just to say that the Nigerian Bar Association, especially, let me speak about Lagos branch, which I'm aware of, has been involved. We have during our meetings what is called knowledge sharing sessions. It's been around for a few years now. During the session, typically speakers will be brought to speak to emerging areas of the law, electricity law, those kind of areas that are emerging in the law. And most of them lawyers will have the opportunity to ask them questions of how exactly they can actually participate in those areas, and so on and so forth. So I think that has been one way that the Nigerian Bar Association Lagos branch has try to ensure that lawyers are upskilled and they have the capacity to play in those emerging areas. Again, also, there is usually the Law Week program of the MBA, especially in Lagos branch and many branches of the MBA that I know. Usually a period also when lawyers are given the opportunity to come and learn, and they bring speakers from different areas to come and speak about emerging issues. Not just emerging issues, but even issues that we may not be aware of or are not very conversant about. So I think those are some of the ways that the MBA has tried to close that gap. But I think beyond all of this, much more effort can be done in the MBA, especially in the Lagos branch that I know. Beyond those knowledge sharing sessions, there can be sector-specific programs. So just imagine that this week is just a day or two in so month is called maybe FinTech Week or FinTech Day. Somebody, a number of speakers call maybe a webinar or something of that nature to come and speak on webinar will come and speak on fintech, for instance. Not just speaking on fintech, maybe have a few agreements, take us through how agreements are drawn up for fintech agreements are drawn up, you know, those kind of things, specific issues and in-depth things, not just a 40-30 minute session. So those, by doing so, I think we can further deepen the capacity building program of the Nigerian Bar Association.
Okay, thank you very much. Thank you very much. Now let me allow Ms. Sapata to address the issue better, since she says she has been in the NBA better more than you and has done a lot more.
Not address it better, just add a bit to what Ikechukwu has very eloquently provided. Now, in addition to those, we must give some credit to the sections of the Nigerian Bar Association, because a lot of the time they tend to run trainings. Now, I will speak more for the section on business law, because I chair a committee there and I know the amount of work we have had to put in, and I'm also quite aware of the amount of work quite a number of the other committees have put in. The reason being that the main objective is to provide training to young lawyers. And it's not just in Lagos, because that was also another challenge. In far-flung areas of our nation, a lot of things, part of the complaint was that a lot of things tend to happen in Lagos and Abuja, and maybe sometimes Port Harcourt. So efforts have been made. We've arranged training in Warri before. There was a training we're working on for Yenogwa, I think for the law school campus in Yenogwa, but we didn't take effect because it was too close to their exams. So the point I'm making is, in answer to Professor Shodipo's question, that on training he says, in what ways can the NBA ensure that lawyers grow increasing relevance in emerging sectors, of our economy that have grown? I think training is it. It's got to be training. And a good example is what the Lagos branch of the NBA has done, approaching the Chartered Institute of Arbitrators to train, I think, about 100 lawyers on arbitration. Sometimes these trainings are sponsored. So it's just for lawyers to indicate their interest, make themselves available, and they obtain this training. So I think that's really the best way to go. 3 things: training. That's the truth. It creates an understanding, it builds interest, and of course, it builds the capacity. So I think that's the way to go.
Okay, well, thank you both very much. There's a question here that's for Prof, but I'm going to ask both of you. I don't know if if the other panelists are still here. Okay, Ms. Onye is here, so I'm probably going to share the question. But then before we continue, there's something I'd like to add. So yes, I think I agree completely with the training. But I also think that there are other forms of training too that we can explore. So for example, I think the internship thing that Onye was talking about, so we can find how we can include that in. So that also is a form of training, really, because you're exposing that person to that area of practice. And that's basically what I thought to add. But now to Prof, for the question for Prof, from the question was that that's from Undubisi Okonta. It says, Prof, I do not know whether I missed this, but if I'm going to say blah blah 5. Okay, let me just ask the second question. The first question seems to me to be somewhat, but then at what stage does advertisement become solicited?
Sorry, if I'm to speak to that, I'll just say Undubisi should be patient and wait to receive Prof's, slides, because he actually said he gave very clear distinctions between advertisement and solicitation or soliciting. So I think he will get his answer. Prof is actually the best person, he's in the best position to have answered those 2 questions. But I think the answers are in his slides, which he had wanted to share with us and has assured us that he's going to make available, or he's made available.
Okay, thank you very much. I'm not sure. At this place, you have said Profs will be the best person to answer. I'm not sure I should ask the other 2 people again. Should I go ahead? Mr. Wana, do you want to say something?
I abide by the decision of my able learned senior.
How about Onye? Do you have any, Miss Onye? Do you have any? Do you want to add something? Okay, I'm not sure she's online at the moment. Okay, so does anybody have any further question? We're already gone past our mark, but if there's any question, you can ask now. Otherwise, I will thank everybody and we'll go. Unless, of course, any questions? Okay, well, while we're waiting for any questions, is there anything that any of the panelists would like to say? Anything that you'd like to add, or just okay, Mr. Wana is shaking his head, so that's the no.
Other than to say thank you, for this time and for the patience of those who are still here at this time. I think it was supposed to be for 2 hours, 3 to 5. So I think stretching it by 45 minutes, it's a pretty long stretch. So thank you very much. And thanks to Mr.
Akosobi,
Mr. Akosobi, and of course yourself, Fernandez, and
Jude Nodum,
and of course the rest of you, because always there are people behind the scene. It's been a pleasure indeed, and I have actually gained a lot of insight. I have learned a lot myself, listening to all other panelists, clearly including Mr. Owen.
Okay.
Thank you.
Well, thank you all very much. Thank you very much for coming. First of all, I'd like to appreciate Threshold Attorneys and Kechiko Wana myself. You people, well, you have done quite a bit. Mr. What's his name? No, Threshold Attorneys and Mr. Akosobi. I'm coming to Mr. Wana later. Mr. Akosobi is a very, when he wants to do something, he really will do it. He'll push through whatever he needs to get to do it. So I appreciate him very much. I appreciate Threshold Attorneys for coming up with this and for following up. I appreciate the panelists for being here. I appreciate those ones that came and could not stay and had to go. Those ones that have stayed till this time. I appreciate you all very much. For my co-moderator, well, thank you for coming on and staying at this time. And I thank myself too for coming. So a recording of the session will be sent to us within 24 hours, within 24 to 48 hours after this session. We'll also try and send a Q&A report that shows the questions and the answers. As much as possible, we'll also send the slides and work for all the persons who attended. So we'll try to keep us updated. We'll also try and the recording of this will be available. It's already available on Facebook, but it will be made available to everybody. It will be shared to the emails along with the other items so that we can keep up the work. I'm not sure, but I discussed with Miracle and there was supposed to be some sort of report for the session again to highlight key things that were discussed in the session. I hope that will be included in the final report that will be sent in. But thank you all very much. Thank you all very much for an exciting time. I appreciate it. Have a lovely day, everybody. And please stay safe. Please stay safe. Stay safe. Stay safe. Stay safe. Stay safe. I know Mr. Wana has warned me not to go for protests anymore, but I think I might go.
You're on your own. Please do not go.